you know, that's it's a pretty brave dog.
Looks like we have 3 students with us so far. I guess we can give them a few more minutes.
Yep.
I'm just gonna listen in, but wanted to welcome you and thank you.
Sure. Yeah.
And
Thank you so much.
Yeah. How's the school year been?
crazy.
Yeah.
We're all working from home primarily. Getting folks into the office just when we have to do some student documents.
Yeah.
Students most of the classes are remote, virtual, online kind of thing. We have students scattered around the United States and around the world and on campus, and
Right.
trying to keep up with all the changes in the government guidance. It's
Right.
crazy. Yeah.
Because you've got a lot. I'm sure you have F1s who can't come.
Yes.
Oh wow.
And some of them deferred to January, and of course we still don't know what's going to happen in January. So yeah.
Huh.
Well, I guess I better hush and let you guys get started. We have students listening in and waiting on us, so I will.
Okay.
I'll step aside, and thanks again.
Yep.
Greetings to Scott.
Right now, everybody, I set up everybody except presenter, Hugo, everybody mute right now. But if the student has any question, you can unmute yourself. Then you can ask question. Is that okay, Hugo?
Yes, that's fine. I'll have as we go, I'll ask if people have questions.
Okay. Yeah. Please unmute yourself. Okay.
All right. Well, whenever you're, I'll just hang back until you tell me to get going, and we'll start.
I know. How about wait 1 minute?
Okay.
11:05. That's okay.
Sounds good.
Almost 11:06. So shall we start?
Sure. Okay.
Thank you, Hugo.
Well, good morning, everyone. This is, I have a presentation ready, which I'm going to go through, but as we go through, I'm going to pause for, if you have any questions on any of this. So as we get going, this is what I want to cover today. Just basically, first I want to touch on just very briefly what the basics of immigration law are and how they affect you as you go through this process. It's good to know the terms and what we're dealing with. Then we'll talk about some options for students generally. I know this is going to be focused on the H-1B process, but there may be other options that are available to you, and we'll touch very briefly on what those might be. Obviously, then we're going to talk about the H-1B process, and at the end, looking ahead, I think it's useful to just touch upon what would be involved in gaining permanent residence in the U.S. through a job. And of course, like I said, questions at the end and sprinkled throughout. I'll be soliciting them throughout the presentation. Okay. So this is just a fun illustration of the multiple paths available to permanently settle in the U.S. I mean, this is it's an illustration of that it's a highly regulated area of the law, but there are multiple paths to actually become a resident and eventually a citizen of the U.S. They're multiple, but they're defined. What we're going to focus on is the sort of path that's at the bottom third of this cartoon, and it's about which focuses on employment-based immigration. Okay, so I assume Erica that I would make this available to whoever's in this presentation. It can be emailed to them, or if they want a copy of this slideshow, they can certainly have it. So as we go on, the main thing to remember about immigration laws, there's really only 4 ways to permanently move to the U.S. It's either through family-based immigration, either through immediate relative, which would be mother, father, or spouse, generally. An employment-based situation where you have a job offer. Humanitarian-based, which generally means an asylum petition, or other. And the other primarily means a lottery system, which we won't touch upon in this presentation at all, but it is certainly one of the ways that you can avail yourself of the possibility of gaining permanent residence in the U.S. So beyond that, there's a few key terms I want to touch upon. The word alien appears a lot in the immigration context. The reason it's a defined term. It's a term of art, as they say. It's a person who's presumed, it's a person of a foreign-born person in the U.S. That's how the Immigration Naturalization Act defines it, okay? An immigrant is a person who's presumed to stay in the U.S. A non-immigrant person is not presumed to stay in the U.S. So every time you try to get a visa, the presumption is that you want to move to the U.S. and stay here permanently. And your job in every immigration process is to rebut that presumption, or to get over that assumption that the government has for anyone who tries to visit the U.S. There's the issue of visa versus status. When you go to a consulate, you present your passport, you go to an interview, you present your passport, they stamp a visa in your passport. That visa is only good to be admitted into the U.S. Once you're in the U.S., your visa is no longer necessary. What you need in the U.S. is status. That's what your I-94 gives you. And if you guys are F1, your status is determined by your I-94 and your I-20, which UIS gives you, okay? And then the issue of lawful status versus unlawful presence. You're in status as long as you're complying with the terms of your visa, the terms of your I-94, and as long as you don't stay longer than the government allows you to stay. admission is determined, and admissibility is determined every time you travel to the US. Every time you travel to the US, every time you arrive at O'Hare or Atlanta or New York, you are applying for admission. And the government has to make a decision whether or not to accept your application to be admitted into the US. So those are a few, just a quick background on those key terms. Any questions on any of that? Okay. So you may have already dealt with most of these agencies, but again, just just a little primer on what we're dealing with immigration. The U.S. Department of Homeland Security is the big overall organization that deals with immigration, and it's broken up in three parts. USCIS is the agency you would use if you're going to apply for an employment authorization document after you complete your studies to get OPT, or to apply for an H-1B, which is what we'll be talking about. CBP, which is Customs and Border Patrol, are the friendly officers you meet at the airport when you arrive at O'Hare. Those are CBP officers. They're under the Department of Homeland Security. And Immigration and Customs Enforcement, ICE, are the people who are the enforcement number. They're the folks who arrest and remove people who should be removed from the U.S. If you're ever in a situation where you need to be removed for whatever reason, he would interact with ICE. So we want to avoid interacting with ICE if possible. The U.S. Department of Justice is who administers our immigration courts. So if you're in a situation where the government wants to present a case that you should be removed, you would be under the Department of Justice jurisdiction. The U.S. Department of State, you've dealt with at any time you've applied for a visa outside the country. So those are the consulates and embassies abroad. And the Department of Labor is who you deal with the H-1B process and the employment-based process when you're dealing with wages and what you will be paid pursuant to either H-1B or a green card. So move on. And this is how the agencies kind of work together. Again, you've already probably noticed this. If you've traveled from abroad, you have this double check system. The first part of the system is you apply for a visa abroad. With your I-20, if you're a student, UIS would issue your I-20. You would take that I-20 to your interview outside the US at a consulate or an embassy. That's where you interact with the Department of State. So that's the first level of checking. And the second level of checking would be at the airport at CBP. CBP doesn't have to automatically honor the visa that was issued at the consulate. So you have that level of scrutiny as well. Most of the time it is honored, but again, you have to have both those agencies approve both the issuance of the visa and then admission into the US. And then the third level, of course, as we talked about, ICE would be the enforcement arm of the immigration law, and Department of Justice would be if you're in front of a judge arguing about whether or not you should be removed. Again, we want to try to avoid, if at all possible, ever dealing with ICE in your situation. The triple check system is basically if you're asking for a change of status in the US. So in your case, when we're talking about changing from F1 to H-1B, your first step would be to ask USCIS for their approval and change you to H-1B. Once you have that approval, the next time you travel to outside the US, you're going to have to get a visa to come back in the H-1B status. So you need to get an H-1B visa. So that's the second check. You need to get to a consulate to get a visa to be admitted back in the US. And then the third level of checking would be upon return to the US with CBP at the airport. Is that clear? Any questions so far? Okay. So it's a framework for the process. There's two general categories. where there's temporary visas, non-immigrant, and immigrants. You guys are not immigrants. If you're a student here as an F1 or J1, you're a non-immigrant. An H1B is a non-immigrant. Immigrants are only folks who are legal permanent residents, um, as denoted by this lovely green card, which is also, which officially has the name of I-551. Everyone else is a non-immigrant. Either you're coming to Disneyland, or you're coming to study, or you're coming to work on a very specialized project under H-1B. Those are all non-immigrants. And these are the different, call an alphabet soup of non-immigrant visas available to you. There's a professional work visa. There's H, which would the H-1B would fall under. L's are for people who work in multinational companies who have a presence abroad, and you're a manager or specialty worker outside the U.S. and you want to be transferred here. TNs are for Canadians and Mexicans who in very specific occupations. E3s are for Australians. And the H-1B one are for Chileans and Singaporeans. Those are all based on a job offer in the U.S. and and then it depends on your particular skills and level within your organization. There are seasonal visas, the H-2A or H-2B. Again, those are mostly determined by industries. They're requested by industries that have seasonal type work. So resorts, hotels that are open for ski resorts in the winter, or summer getaway type places like in northern Wisconsin. There's a large industry of hotel workers and restaurant workers who are under the H-2B program. H-2A is for seasonal work having to do with agriculture. So again, it's mostly for farmers who need help on specific times of year. Then there's visitors and students. Visitors is a B visa. That's, again, if you're coming here to just as a tourist. F are students, of course, and J's are exchange visitors. And so, and oftentimes J's are also scholars. So if any of you are J's, then you know what that means. And so then beyond that, there's E1s and E2s, which are for folks who have some money to invest in the U.S. There's no limit, but you have to be from a country where the U.S. has a trade treaty with, and this is an option for folks who maybe have some money to invest in the U.S. in a business. This could be an option, an alternative to the H-1B, and we'll talk about why alternative might be necessary in a second. All of these visas, they're different from legal permanent residence and from immigrant visas because they're limited in time and scope, and they have an end date. At the end date, you either have to leave, you have to change your status, or you can extend your status depending on the type of visa. And generally, you have to deal with either USCIS or an embassy outside the US. All right. The immigrant visa, again, allows people, as I just touched on that again, allows people to work indefinitely or permanently. People in this category are referred to as legal permanent residents. It allows a pathway to citizenship, and it allows employment permanently, and it allows eventually to sponsor family members to come to the US. This is where we want to get to, because from an F visa holder can eventually get to this path if they follow a specific route. And these are the different ways to change your status from F to another non-immigrant status in the US. And so we touched on all these before. Beyond the non-immigrant visas, which are H, the L, the E, the TNs, You could potentially try to stay here if you have an employment-based immigration system, through a family member. If you have a boyfriend, girlfriend who's a U.S. citizen or a legal permanent resident, this might be an alternative way for you to stay here, that's available to you. If there's a potential asylum claim that you might have, that's something to be explored. And of course, the diversity lottery system, which again, we won't touch on, but it's also available for folks who want to try to change or maintain status in the U.S. So compliance is required to operate in the system. Now, working without permission is one of the most typical obstacles that people will find in dealing with this. So it's really important to try to avoid unauthorized employment. Because unauthorized employment, if you're an F, it's a violation of your status. And so if you ever violated your status, since counted from the last time you've entered the U.S. in your status, you may be unable to change status to most categories. It could lead to removal. For F, this is not as big a concern, but it's certainly something you need to be aware of. Unlawful presence can be an issue. Unlawful presence is the period of time you're here beyond when the government allows you to be here. So if you have an I-94, your I-94 is the document that you receive when you are admitted into the U.S. That form typically has an expiration date. If you are more than 180 days in the U.S. after that date that's on the I-94 without permission, then you would be barred from coming to the U.S. for 3 years. If you're in the U.S. more than a year after that expiration date, you would be barred for 10 years. So again, I'd mention there's a distinction for F students. Most of the time, Fs don't have a specific date listed on their I-94s. And so if most of the time you would have something called duration of status. So if you have that on your I-94, then because there's no specific date, unlawful presence is not necessarily an issue, unless someone makes it, USCIS or a government agency makes a determination that you no longer have status, and as of the date of that decision, then unlawful presence could become an issue. So again, it's something important to keep in mind. And unauthorized employment can trigger all of that. And also, of course, unauthorized employment could lead to possible inadmissibility in the future. If you're at the airport, you're coming back from a vacation back home, try to come in with your F visa. If it comes out that you worked without permission in a previous stay, you could be denied admission in the U.S. So the big rule of thumb for this, the big takeaway for unauthorized employment for folks in student visa status, always act before you ask. If you're not sure whether or not you can work with authorization or what you're about to do is allowed, ask Erica, ask Rick for advice before you take any steps like that. Any questions on any of that?
No questions so far?
Okay, great. Any comments, Rick or Erica?
Oh, sounds good.
Rick.
Okay, great. All right, so this is just a general illustration of what we're talking about, what we've been talking about so far. So in the non-immigrant category, the way you're going to show your status is through your I-94. Does everyone know what the I-94 is, by the way? I hope so. You're going to need it. Meg?
I guess
I'm assuming they do. Okay. So your I-94, your I-20 are the things that are going to determine what if you're in status. Okay. So those are your key documents now. Later on, if you're able to stay in the U.S. and you're able to get sponsorship either through a family member or through a job, you would become a permanent resident and you would get the green card, which is called an I-551. And after a period of time, depending on how you got that green card, it would lead to citizenship. The main difference between a U.S. citizen and a permanent resident, two things. Number one, U.S. citizens are the only people in the U.S. who have a right to be in the U.S. Everyone else in the U.S. Is here by operation of a statute or by any whim of Congress. U.S. citizens can never be, generally speaking, have a right to be here and can't be forced to leave the U.S. Everyone else could. So that's one of the things I was emphasize to folks. If you have long-term plans to stay in the U.S., that's where you want to get to. Of course, the other big thing as happened a couple weeks ago, U.S. citizens are the only ones who can vote. So, all right. So now we get to the nitty-gritty. The H-1B. What does it require? It requires a job offer, number one. And it can't be just any job offer. It's got to be a job offer for a position that requires a specific bachelor's degree. Now, and that's important. So, but before I get into this, I mean, the H-1B program is a great avenue to maintain status and to continue your professional development in the U.S. And so and for students, it's typically the way to keep in the U.S. While getting further along in your career. So once you have a job offer, and that job offer it requires a bachelor's degree, so it can't be a job at Walmart as a cashier. That wouldn't work as an H-1B. It's got to be a job that requires at least a bachelor's degree. If it's a job at Walmart that requires you to work in the analytics department to determine what needs to be stocked at different times, that's more a position that an H-1B would be required for, because it's a job that requires a bachelor's degree. Then you'd have to present evidence that a job like that would require a bachelor's degree. So an analytics position at a retail job, for instance, you can find ads that would be evidence that a job like that would normally require a bachelor's degree. So you'd have to present something like that. The employer would have to be willing to pay you the prevailing wage for that position in the area of intended employment. So what does that mean? The Department of Labor has a schedule of wages, and it determines what each job should pay depending on where that job is located. So a software developer in Springfield is going to be probably paid at a lower level than a software developer, say, in New York City. So where the job is located is very important in determining what the prevailing wage is. But bottom line, the employer can't just offer you whatever wage scale they think is appropriate. They need to be willing to offer you what the Department of Labor says that job in that location should pay. And then, of course, the fourth part is you have to show evidence that you have the credentials necessary for that job. So if you have a bachelor's degree in English and you got a job and you want a job in the analytics department in Walmart to do analytics research and programming, and that normally requires bachelor's in computer science, that's probably not going to work. You would have to show that you have a degree that's uh, that's in that occupation. And so what we call those are specialty occupations. The specialty occupation is a general term that the government uses to describe a job that requires at least a specific bachelor's degree. That's a specialty occupation. So you have to have a degree in that specialty occupation yourself to be able to qualify. Any questions on that?
I have a question, please.
Yes.
Is there a minimum salary requirement for H-1B visa?
Mm-hmm. Yeah, the employer can't just pay you what they think is fair. It's what I was saying before. The Department of Labor has a list of wages for the occupation, for any occupation in the U.S. So, and that's determined by experience required. It's determined by the job description, and it's determined by where the job is located. And based on, so you would check against the Department of Labor database, and based on that, on the examination of that database, that they would have to be willing to pay you at least the amount listed in that database.
Thank you.
Yes. So it's a job offer and the employer's willingness to pay the prevailing wage. Now, what's the framework? Now, the H-1B is a great program. It's a great path for students who want to continue developing their careers in the U.S. after OPT. But there's some problems. The biggest problem is supply and demand. There are way more people who want H-1B positions than there are H-1B visas available. Every year, the government, by law, only can give out 85,000 H-1B visas, meaning H-1B visas are capped at $85,000 a year. So when we talk about the H-1B cap, that's what we're talking about, the limit of how many H-1Bs are available every year. 20,000 of those are reserved for people with U.S. master's degrees. So if you have a master's degree in a different country, you wouldn't be eligible for that 20,000 reserved number of H-1B visas. But if you're a master's candidate at UIS, then yes, I mean you would have a better shot of being picked in the lottery. The way the lottery has traditionally worked, and I said has traditionally is because there's a possibility that this year things might change, but I'm just going to go with what the law is right now. There is, because the demand is so much higher than the supply, as a point of illustration, in 2019, there were 275 workers who filed for H-1B status and only 85,000 slots. And so the way USCIS manages this demand is by lottery. And the lottery, which occurs in early April, is determined first by picking master's degree holders for the first 20,000. And then those master's degrees, whoever doesn't get picked gets put in the general pool, and then the next 85,000 are picked from the general pool. So basically, as a master's degree holder, you have two shots of getting picked under the current system. Each year is counted by the government's fiscal year. For the U.S. government, the year starts October 1st. The earliest date you can apply to change to H-1B status is 6 months prior to October 1st, which would be April 1. So that's why the lottery happens in April, early April. So bottom line, if you want to compete for one of these, you have to be ready with a job offer and everything else that's necessary to be in this lottery by April 1st. Any questions on that?
How will be the law changed
Yes.
If you have any idea.
Yeah. So what's being proposed right now, it has to do with this wage issue. So the lottery that I was telling you about is just basically a blind lottery, and the only distinction is who has a master's degree and who doesn't. If you have a master's degree, like I said, you have 2 shots at getting picked for one of these 85,000 visas. What they're proposing on doing is prioritizing jobs that pay the highest. So if you have a job offer that pays an entry-level wage, you are going to have a much harder time being picked in the lottery, as opposed to someone who has the highest wage possible for that job in that area. So it's only proposed right now. That is not the law yet. I assume there's going to be litigation, meaning the government can, in this country, the government can propose a rule, but but institutions and citizens and and people in the U.S. could sue the government before court to stop changes that are we might consider unlawful. So that's what I mean by litigation. A judge is it's going to be disputed, and a judge is going to have to decide whether or not this is a lawful change. So, like I said, the law right now is straight visa lottery. The only distinction is U.S. Masters. The proposal is to prioritize higher waged positions. Okay. So stay tuned. Any other questions? All right. You know, a quick word on cap gap. This is something, if you're either an OPT or you're finishing your program, that it's a benefit that you guys have. So your program ends. So the H-1B program, if you're picked, starts October 1st. But your program doesn't go to October 1st. Your programs end in spring or in summer. So what do you do? What do you do for that period of time between the time your program ends? Even if you have the 60-day grace period, it's not going to reach October 1st. So what the government does, what this benefit provides, is that as long as you have an employer that has filed an H-1B petition for you before the expiration of your status, either while your program was still going, or before the 60-day grace period after the end of your program has ended, as long as they file an H-1B petition before then, you're able to be in status until October 1st. And hopefully by October 1st, you should be able to, USCIS, depending on how they're filed, should have an approval for your H-1B for you to start working as an H-1B on October 1st. Any question on that? We usually get questions on this, but no, all right. All right. So this is an illustration of how the process works. Several steps. So number one, at the top, obviously you're an international student, graduated, you're already working under OPT. Of the people here, who has OPT and who's just graduating right now?
I have an OPT.
Okay. Campana?
I'm graduating in May.
Okay. All right. Are you applying for OPT?
Yes, I'll be applying next in February.
Good. Okay. And Meg? Okay. All right. Moving on then. So if you don't have if you're a graduate, probably the best thing to do is to apply for OPT because it's a sure thing. There's no limit to it. It's something you get automatically. It's an extra year of status that you can stay here and work in a job that's related to your field. But that doesn't stop you from also applying for H-1B as well. If you find an employer, you can do both. So while you're in OPT status, if you find an employer who could offer you a job in a specialty occupation, as defined before, a job that requires at least a bachelor's degree, or that you have, then that process would have to start with the employer calling us or your attorney, whoever you work with, between sometime in January and February. If you wait until March, then you're running into issues where time's going to run out. Because remember, you have to be ready to go with everything set for this registration and for the lottery process by April 1st. So this is a time-sensitive process. So January, the 60 days between January and February are key. If you have a job offer, the employer would work with your attorney to move forward. They would register you, and they would register themselves for the lottery, and that would happen in March. And that registration process happens online on the USCIS website. And in April, first week of April, that a lottery occurs. And if you're picked, then the employer has the opportunity to file 9129 for change of status from F to H-1B. And they would have 90 days to actually get that application on file. So the 90 days obviously would be whenever that selection was made, sometime in early April. 3 months would be early July. And so what that means is that within that period, you have a cap gap issue in the sense that you want to make sure that your employer files your H-1B while you're still in status or you're within your 60-day grace period at the end of either your graduation or your OPT status. Okay. So those are all the competing timelines you have to deal with in getting it on file. Getting a change of status or an H-1B petition filed in a timely manner is very important. So pay attention to all those deadlines. The April 1 deadline, the March deadline to register, the April to July timeframe to file an I-129 if you're selected in the lottery, but also paying attention to when your status actually ends so that your employer can take advantage of gap benefits. So that's filed before your grace period ends or before your OPT ends. Once filed, you will get a receipt notice, and that's proof positive that USCIS has accepted your application. And that's the confirmation that you know that this process is on its way. Until that happens, we have no confirmation whether or not USCIS has accepted our application. So that receipt notice is going to be our confirmation, and it's going to have the date that it deems your filing effective. Again, and that filing date is going to be important when determining whether or not it's a timely filed application. Again, talking about what we just talked about in terms of filing it while you're in order to get cap gap benefit. So after it's receipted, it could take 3 to 6 months. Hopefully get an approval notice. The approval notice, if it's a change of status, which I'm sure most of this will be, you'll have a 994 printed at the bottom. And that I-94 is basically going to have you change your status from F to H-1B, and it'll start no sooner than October 1st. Okay. Any questions on that?
So what if you're working and this process is going on? What happens?
So you can still, there's nothing that stops you from working on this process unless your EAD expires. When does your EAD expire?
EAD is expiring January, end of January, January 31st.
Of this month. Okay. Yeah. Yeah. So then you have so what happens after that is you have 60 days of grace period after that. If your employer is not able to file an H-1B before that the end of that grace period, it may be you can still go through the process. They can still potentially approve the H-1B. You won't get a new I-94. So what that means is you would have a status approval, but then in order for you to become an H-1B, you'd have to leave the country, go to a U.S. embassy or consulate, and get a stamp and come back in as H-1B.
Okay.
All right. So this process could still work out, but it may require you to, you may not be able to change status. It may require you to leave and come back with a visa. And hopefully right now that prospect is a little dicey. It's not as clear right now because of COVID. A lot of consulates, as you may know, are still not back to operating on a regular basis. They're not processing visas as they normally would. And there are executive orders in place that prohibit certain types of visas being processed. So hopefully by next year, if you do need to consular process, with COVID becoming more and more resolved, and with a new administration, consular processing again becomes an option for someone like you. Other questions? Looking ahead, after you are in H-1B status, this is a process for changing jobs. The place where it becomes different is it depends on whether or not your employer is CAP exempt. Now, a word on this. What does CAP exempt mean? So most employers in the US who are private employers are going to be subject to this 85,000 visa cap, okay? Employers who are not required to abide by that cap, meaning they can apply for an H-1B at any time because they're not limited to how many H-1Bs or when they can apply for an H-1B, typically are universities or schools or institutions that have programs related to universities or schools or research projects. So if you get a job, if you're offered a position with an institution along those lines, you may not have to worry about getting in the lottery at all. And you can apply for a visa at any time and apply for change of status at any time, as long as the position is a specialty occupation. Again, as long as the position requires at least a bachelor's degree and you have that bachelor's degree. So the other way you can become exempt from this cap is if so right now you guys are students, perhaps before becoming a student, you were in H-1B status before. You worked for a cap subject employer before. If you've been counted against the cap at least once in the last 6 years, then you would be exempt from the cap. So that's something else to keep in mind, if that's the case for any of you in the call. The change of employer works if you worked with someone, if you're working with someone who is subject to the cap and you want to move to an employer who's also subject to the cap. If you're working with an employer who doesn't have to abide by the cap because they're a school or they're a research institution or they're an organization that does work with a university or some kind of academic institution, then you would have to go through the lottery again. You can't change from a cap exempt employer to a cap subject employer. But this kind of lays out what the process would be. I mean, once you're in the system, it's a little bit easier to change jobs to another H-1B employer. Questions on that? Now, I just want to just do a brief thing on the future, where this all leads. Obviously, most people want to see if they can extend their stay permanently to make a career here. That seems to be the path that most people want to take. And so I've included this process. So we've got the first, it's basically a two-pronged process. The first part is driven by the U.S. sponsor, your employer. Say you have you've got a job offer, you've made it through the H-1B process, you're working there, and they want to keep you on a permanent basis. The U.S. employer would be your sponsor, and they would have the burden to prove that you're eligible to immigrate to the U.S. under the employment-based system. And so the first step is to work with them. Once they're approved, then the burden shifts to the employee, the worker, you. Then either A, you would work to finish the visa process at a consulate outside the U.S. and get your immigrant visa based on all of the approvals by your employer, or you would change to adjust your status from H-1B in this case to permanent resident. And if that's the case, then you would be able to maintain your status here without having to leave the U.S., but you'd have to be eligible for it. And eligibility is based on maintaining your status, and it's also based on the visa bulletin and whether or not your particular category of visa is available to be able to change and to adjust. Is everyone familiar with the visa bulletin?
No.
Okay.
No.
All right. The visa bulletin is you can Google it, and it's put out by the Department of State, and it's published once a month. It usually comes out around this time of month for the following month, and it determines it's a way to manage the flow of people trying to apply for immigrant benefits. In this case, in your case, if we're talking about changing status from H-1B to green card in the U.S., either adjustment or through consular processing outside the U.S., your particular category has to be current. And the way you determine whether or not it's current is through the visa bulletin, which is checked every month. So when the time comes, after you find an employer who's willing to sponsor you, after you find an employer who's willing to test the labor market, and I'll describe what that means, and it's able to prove that you're eligible to immigrate to the U.S., then the only way you can become an immigrant is if the visa bulletin says you can. And so that's why it's an important tool to check. And if your number is current, if your date is current, then you can apply for either adjustment of status or apply for an immigrant visa outside the U.S. So this is how generally that illustrated process works. So right
Hey,
now,
Hugo.
yes.
Oh, I'm sorry. I think my mic was not working. I have one question on the OPT
Yes.
part, right?
Yes.
Yeah. Okay, cool. So, if an employer offers a job which is completely remote, okay, within the United States, so
Yes.
do we have to file something while on the OPT and also while applying for H-1B?
Well, so let's see. So they want to offer you an H-1B position?
Yeah, so the company is based out of California,
Yes.
and you can work from Chicago,
Yes.
remote. So do we
Yeah.
need to file something specifically while an OPT and also on an H-1B?
No, I mean, you can, the issue of remote comes into play when you're talking about the location of the employer is important because the H-1B has a wage, as a prevailing wage component, meaning they've got to be willing to pay you um, what the Department of Labor says is required for that position, depending on where you're working. So if you're working remotely in Chicago, then your salary would be based on where you're working from, i.e., Chicago,
Okay,
not California.
okay.
Unless you're going to be working, are you going to be working on at other places beyond Chicago? Are you going to be working at employer site?
No, it's an offer that you can work from anywhere in the U.S. And since I have an option to live in Chicago and work from there and work in that region, so
Yeah,
yeah, that's it.
yeah, that's the way it would work. I mean, you would do it based on where you're actually working. Um, but in OPT, there's no salary requirement, so that's not an issue for the OPT part. But if you do move beyond that to an H-1B, then it would be where you're working. So,
Okay,
Chicago. All right.
okay, cool. So just the wage level matters, nothing in terms of reporting that you're working on, not an on-site or something like that.
Well, it depends on, again, it would be on site if you work on site at a client. Um, a lot of these IT consulting firms place their employees to work at a client site. Um, but if you're not going to physically be there, you're going to physically be in Chicago, and that's all you're going to work, then yeah, you should be able just to file based on where you're actually going to work the whole time.
Okay, sounds good. Thanks.
All right. All right. So anyway, this is sort of an illustration of um, how the process works. Now so this is assuming we're already in the system. In the past, you're a student, you're working with another employer. Now you're with an H-1B company. You have 6 years of H-1B, 2 3-year terms. All right. Those 6 years, if your plan is to stay in the U.S. as a permanent resident, those 6 years are the time where you would concurrently, while you're working, have the employer file a labor certificate, do the work necessary to file a labor certification, meaning do the work necessary to prove that there are no U.S. workers who are willing, qualified, or able to do your job. And then also, once that's certified, ask the government to deem you eligible to become an immigrant based on that job offer. So those things happen while you're in H-1B status. And if those things are approved, then you have the option of either adjusting status to become a permanent resident, or if necessary, apply for an immigrant visa outside the U.S. and come back as a permanent resident, working for that company. But so that's kind of the illustration. Hired by the company, either as a student or through the other U.S. employer. You have 6 years of H-1B status, and while you're in that 6-year period, concurrently you go through the employment-based immigration process, and hopefully you can adjust status before the end of that 6 year. Questions on that? But remember that last step of the adjustment of status process, it all depends on whether or not the visa bulletin is current for your country and for your category. So you can do everything except that final step, unless you're eligible. You have to be eligible to be able to take that final step and apply for a green card and permanent resident. And so this is a general timeline. I won't go through all of it because you all will have this available to you. I'm hoping, Erica, I guess you can make that available to the folks who are on the call, this slide of presentation. but essentially it takes some planning. It doesn't happen right away. But it's certainly something that is available to folks who want to stay here permanently, who the offer of a job. Now, all of this is highly regulated. It's pretty complex. And so, do you need a lawyer to do all of this? No, but it's highly recommended, because making mistakes on any of this can have severe consequences. So I put this in here just to give you some tips on how to hire a lawyer, because I shouldn't assume, but if you haven't had much experience with hiring lawyers in the U.S., there's a lot of lawyers in the U.S. And how do you pick one? How do you choose one over the other? How do you do quality control? And so here are some tips that you should look for, you should use when actually looking for a lawyer to help you out with this process. So the most important one is only work with lawyers who are actually skilled in this practice of law. There's a lot of lawyers out there, but there aren't that many lawyers who do immigration law. So it's a very important distinction. It can't be any lawyer. And beyond that, the most important piece of advice is try to get as many opinions as you can. Consult with more than one attorney and compare. And you know, our bar association, the American Immigration Lawyers Association, has a referral service. Pretty much in terms of quality control, that's a pretty good source to start as far as looking for folks who would be qualified to do this kind of work. Okay. With that, are there any? I mean, that's the presentation. Are there any general questions or any clarifications that I can make?
I have a question.
Sure.
What if we want to apply for, let's say, Canada? So how can an F1 student, a non-immigrant visa, apply for something, for a job in Canada? What is the process, please?
Yeah, I don't, I wouldn't be able to advise you on that. I can certainly refer you to folks who do work in Canada, but that's not something that I work on. So if you want to let me know, if you want to let Erica know your contact information, I can certainly send you a referral that you can work with.
Sure, thank you.
Anybody has other question?
No.
I can see some potential employer maybe. So is there any question if you are employer thinking about hiring, you know, somebody as H1B position? No question? Okay, so already 5 minutes past noon, so we are closing. That's
Very
fine?
good. Very good. Okay.
Okay, good.
Thank you all. Good luck.
Thank you so much. Thank you, everybody.
Thanks, Hugo. Appreciate it.
Sure.
Thanks, Hugo.
Bye now. Bye
Thanks,
now.
Erica.
Yep. Bye-bye.
Thank you so much for all the information.
Sure.
Thank you. Bye.
Bye-bye.
Okay, thank you so much, Hugo.
Sure. And I guess like I was, oh, there's some chat questions. What's this?
Chat question?
Oh, there's some chat questions.
Yeah, some chat, sort of like, you know, Michelle wrote, thank you. Then Rick said, you know, send
Oh,
an
gotta
email
run.
to, you know,
Okay. Oh, good.
ISS.
Okay.
Yeah.
So if you so you have this, I don't know, I'm fine with you sending this to whoever